the emoji was like, I was trying to type a friendly emoji and it just was like not coming out right. And then I was like backspacing and doing the wrong thing.
You didn't get the winky face out on time.
It was, I'm sorry, it was a kitty cat happy face.
Yeah, we're almost, just to warn you, we're almost to going live.
Okay, we're done. I'm logging out at
Oh, it's
this
okay.
minute.
It's take your time. No rush. I'll warn you before I go live.
Massive upgrade.
Yeah, no rush. Take your time.
Yep.
You ready?
Ah, yes.
Oh, good, because we've been live for like the past minute. Just to let you
I
know.
mean, look, I would not. I
like,
would not even be mad. Look, it's a Twitch stream, Boozy.
Oh, it's a
and
Twitch.
I was playing. It's a Twitch stream, and I was playing a video game.
Technically, it was a game. Technically. Hello, everybody, and welcome back to Boozy's Legal Funhouse for Episode 7, Men's Room Rea and Strict Liability. I'm joined tonight by the prosecutor extraordinaire, Scuff and Dings. Anybody who's listening to the podcast later should now be aware of the fact that all of my guests have fucked up names. I promise you, though, he is a real attorney. This is not me making up a lawyer and bringing them on stream. Before we get going, I do need to read off the names of the Patreon supporters over at patreon.com/lawyersandliquor at the $5 level above. So special thank you to Jeremy the Head Fox and Dragor, Nikolai, Tezcat Magic Jack, Waylon DeRoche, Beaton, Dozer the Trash Panda, A the Weather Fox, Mark Beckwar, Mama T, Uncle Kage, Lisa Lupe, Mark Phaedrus, Netherlinks, Petrov Neutrino, Tyranth, Buddy Goodboy Esquire, CC Otter, David Hunter, Ed B. Colley, Fat Ghost Goat, Grace Jan Gollinger, Ian Delahorn, Jackie, Jason Knight, Coma, Maelstrom, Mark Whipple, Michael Blocker, Pandemonium Hawk, Sean Rabbit, The Dragon Show, Wheelie, and Zeros the Lion. Anybody who is listening to this on a podcast service has now become aware of the fact that everybody's fucked up. And we just lost our prosecutor. We just lost the right as we're starting. So, tonight we are covering mens rea, which is the culpable state of mind, as well as a Washington State Supreme Court decision regarding strict liability in drug offenses. But before that, I'm going to ask if Scuff and Dings is with us, because I have seen Scuff and Dings go in and out several times now. He's with us, but we don't have audio. Just to let you know right off the bat, this is every one of these.
This is going super well.
Like, you understand, this is the recording for the podcast right now. This is what's happening.
I understand.
I don't edit these fucking things. Except to take out the parts where I look like an asshole, because I definitely edit for that. The parts where you look like an asshole, those stay in, buddy. That's not going anywhere. Anybody who listens to the podcast,
I just have to give you a little bit of ammunition, because I am in fact a prosecutor, and I know you want it.
I don't need ammo. I have access to your After Dark Twitter account. I don't need any more ammo than that. So, yes.
Huh.
We'll talk later. So, folks, tonight I have, as always, the 3 legal news stories to start the stream. Scuff, have you reviewed them?
I have reviewed them. I actually sent you a message about how ridiculous one of them was.
Wonderful. I like to hear that, because I guess you're like, I looked at the headlines, which I'm just going to be blunt. That's like the amount of reading I do on them a lot of times. So let's go ahead and jump into that before we get into tonight's discussion topic. The first one from the ABA Journal is federal judges have gone in front of the House committee to discuss the workloads of sitting judges and the need to expand the federal judiciary. Judges and law professors have stated that they think litigants may not be getting their day in court for a very long time, based on the current backload of cases before our federal judiciary. The problem with increased filings not matching increased judgeships has led to cases sitting for up to 3 years. This is following the fact that Congress has not expanded the number of seats on the federal judiciary since 2002, 19 years ago, when they added only a handful of judges to handle the caseload. Now, of course, the GOP is not necessarily against expanding the federal judiciary, just as long as we don't do so until 2025. I wonder why they think that. Scuff, do you have thoughts on this?
I mean, the federal judiciary is such a shit show. I mean, honest to God, is. Like, that's not what they're describing, isn't even half the problem. The other half of the problem is this. So some of you might know this already, but by the Constitution, once you're appointed to a federal judicial position, once you get a federal judgeship, it's yours for life. That's not just the U.S. Supreme Court. That's district court judges. That's circuit court, which is the Court of Appeals, the second level of court for the offense. And then the third level is the Supreme Court. That's the one everyone thinks of. Your appointment's for life. So we got a lot of judges that are in their 80s, their 90s. Some of them are literally in stages of dementia, and they cannot get rid of them. So in addition to the fact that we just don't have enough judges, we have an entire class of judges who are what are called senior judges, which means that they don't hear many cases. By law, parties have to agree to let a senior judge hear their case. So you can potentially skip the line if you let a senior judge. And by the way, I've watched a jury trial that a senior judge was litigating Boozy. His assistant had to remind him to swear in a witness.
I love the fact that you went right for the fucking throat. The federal judiciary is so fucked up, let me tell you how. I love your reaction to that. It was not, yes, we do need more federal judges. The backlog of cases is very concerning due to truncated review. It's fuck the feds, man. Let's go after those elderly judges with both barrels right now. Jesus Christ.
Well, when the Constitution was written, they didn't really write a lot of details in with consideration of like what might happen with the judiciary. Also, keep in mind when the Constitution was written, basically if the case wasn't high treason, it wasn't in federal court. Like, very few cases were ever in federal court when the Constitution was written. Most of them thought of the states as the government. So, like, our system was never designed for the way it works now. No, the federal, everything about the federal system is a shit show, but the judges especially.
I just love that. Now, what about them not expanding? Like the GOP say, "Oh yeah, that's fine. We probably need some more judges in 2025." Like
the GOP being politically duplicitous. Surely you jest. Like,
don't you love that?
Offended.
Like
I am offended, sir.
We've rammed through hundreds of judges, but you need to wait 4 years until we have another crack at the White House before you get anybody. Like, let's not be too fucking hasty here. What's that? We appointed a 32-year-old with absolutely no trial experience, whose only experience whatsoever was writing a brief as an amicus for the Federalist Society in a case. Yeah, no, that's cool. Ignore that. You cannot put anybody else on the stand.
He didn't know what a motion in limine was. I mean, like, that's not even... I know fuck, half of my sovereign citizens know what a motion in limine is. That asshole didn't even know.
Yeah, they thought it was Kool-Aid, limine.
Oh my god.
A motion in limine. Our next news article, once again, comes to us from the ABA Journal. This is something that if you follow me on Twitter, you probably saw me bitching about the other day. A law firm's fan account for the presidential pets is out of the Twitter doghouse. A law firm by the name of Claire Locke actually started a Twitter account called the Oval Office on Twitter to tweet as a fan bio for the president's dogs. People had assumed, I guess, that it was a swipe at Biden and had taken it down. Twitter took it down very quickly. They are now back in active, though, after the owner of the account wrote a letter stating who they are. I want to read this quote. Twitter had banned the fan account as an improper impersonation account, even though its Twitter bio made clear it is not officially affiliated with the White House. The letter writer was supposed to be a Labrador retriever named Gipper, who stated they are not a lawyer, but might as well have a Juris Doctor degree. These types of puns are the reason that I was firmly against the establishment of this Twitter account and may have thrown a minor party when it got suspended. Those types of puns are the purview of dads and furries. Those are the only people allowed to say paw-official right there in regards to a dog. Your thoughts, Scuff?
As long as I'm allowed to say the puns and like torment you with them, I'm cool.
Well, like, I'm not going to stop you. We had a long conversation.
There we go.
We had a long conversation for listeners and viewers prior to starting this tonight, where we established that Scuff is by far the most attractive attorney on this specific call. Finally, it's never a news day without a lawyer behaving badly, is it? From the ABA Journal, an ex-prosecutor has been accused of soliciting bribes from defense attorneys and defrauding a man who had Coca-Cola stock. A former Florida prosecutor has been accused of soliciting bribes for favorable case dispositions and defrauding an elderly man after obtaining guardianship. Former Lake City State Attorney Jeffrey Sagmeister was arrested Friday in Arizona, according to an indictment. Sagmeister, a former state attorney of Florida's 3rd Judicial Circuit for the 6-year period between 2013 and 2019, was accused of taking bribes, discussing them with at least 2 defense attorneys. Both of the defense attorneys were, of course, charged, and asking for political contributions, a discount on a tractor, and purchases of bulls that he owned. I cannot, like, that's the part that does it for me. That's I mean, like, that, when I read that sentence, I had to stop for a minute. It's political contributions, comma, a discount on a tractor, comma, and the purchase of bulls he owned. What I love is, if we go down, one of the defense attorneys who was arrested for this was basically saying, I need help to resolve a case for this client, and then demanded $60,000 from their client for an agreement with him. At the point when Sagmeister was trying to solicit him to buy a bull from a herd of livestock and make a political contribution, Sagmeister sent a text that read, "Are you still on for next Wednesday? I should have charged you triple based on your windfall." What? What? You took the bribe and then you said, by the way, because you're bribing me, I'm going to take more money from you when I sell you my bull.
Everyone acts like, look, sometimes they just make it easy for me. That's all I'm saying.
The best and worst part of this comes when you look at Sagmeister, who was appointed as guardian for an 80-year-old man, Leonard Whitman. Thomas is described as a transient, but had owned Coca-Cola stock valued at more than $640,000 at the time the guardianship petition was granted. Sagmeister drafted a will that designated one of Sagmeister's relatives as the sole beneficiary, and converting assets to cash and depositing the funds for his personal use in his own accounts. And that actually offends me more than the bribery, to be honest. That part bothers me more than the bribery. Like, it probably doesn't bother you more than the bribery. This is one of your colleagues.
No, it's not.
He was a You're a prosecutor. He's a prosecutor. Look.
Former. See, every time you bring one of these prosecutors behaving badly case, it's a former prosecutor. I could tell you stories about current prosecutors behaving badly.
Only by the grace of God is it a former prosecutor. Let's just be honest here, Scuff. Let's not engage in high grade bullshit on the stream. Like, you gotta tell me right now there is no prosecutor you can think of, and I'm not asking you to name names yet. There is no prosecutor you can think of right now that is acting unethically and is currently in office.
Oh, for sure. I mean, I told you, one of my former prosecutor colleagues, while I worked with him, was indicted by the feds and spent a year in federal prison.
Okay, yeah, but I said is currently in office. Like, is sitting there right now, high on their pile of bull sale cash, unable,
sure,
not being touched.
I don't know of them personally, but certainly there's like hundreds of prosecutors. There's thousands of prosecutors around the country.
Sitting on top of a pile of bull sale money that they've solicited for bribes? Like, how big is the cattle market amongst prosecutors? I'm curious now.
How many prosecutors do you think there are in Oklahoma, Texas, Idaho, Kansas, Missouri, Kentucky combined? There's got to be some.
Why do you think Kentucky has like a huge livestock industry of bulls? Like, I'm from there, and I'm just gonna tell you, bulls, not the livestock we deal with.
I don't know anything about Kentucky except you're from there. And whiskey.
We have horses.
There you go.
Yeah, we have horses. There's plenty of horses in Kentucky. Oh, and now on to tonight's topic. Now, as is usual, to get to the thing I want to talk about, I have to assume that everybody out there is an idiot and has no idea about the thing that makes the thing I want to talk about so interesting. And I have been told by several listeners over the past couple episodes that I talk too damn fast to be understood. So, for the people who are live tonight, I've got a PowerPoint. I spent a long time on this PowerPoint, and it will be, for the listeners, available at lawyersandliquor.com for download with the posting of this week's episode. But this PowerPoint is Basic Criminal Law Mens Rea. A quick boozy discussion. First, let's talk about two things that are necessary for criminal conduct to hold a person to be found culpable. The very first one is the mens rea, the guilty mind. This is the state of mind that is necessary for a person to be found criminally culpable. Generally, it requires that they intend a criminal act or act aware of the criminality of it. There is also the Actus Reyes, the guilty act. That is the act itself, the criminal act, the physical thing you do that consummates the commission of a crime. The general term at law is Actus Reyes non facit reum nisi mens sit rea. I killed the Latin on that. I don't care whether I did or not. Translating to, the act is not culpable unless the mind is guilty. The takeaway from this is very simple. You can't have criminal culpability unless you have both the mens rea, the guilty mind, and the actus reus, the guilty act. Now, there are differing levels of mens rea out there. There is the purposeful, intentional level, which is, I meant for the crime to result. The knowing level, which was, I'm pretty sure a crime would be the result of my actions. The reckless level, which is, I was aware there was a substantial and unjustifiable risk that a crime would result, and I did it anyways, because I don't give a shit. The negligent level, which is a reasonable person would be aware of a substantial and unjustifiable risk that a crime would result, whether I was or not, and strict liability. I did the thing, and what I knew or didn't know doesn't really fucking matter. Now, what level will you apply to criminal conduct? Well, the very first thing you have to do is look to the law. In many areas, the statute that defines an offense will state what level of mens rea is needed for that offense to be held culpable or culpability to be held against somebody. All right. So the statute may say somebody who purposefully or intentionally or knowingly or recklessly or any of those things does this thing is meeting that mens rea requirement. And if the statute is silent, you just look at the law harder, because most states somewhere in their code, their criminal code, will say, hey, if we don't tell you what the level of mens rea is, then here it is in a simple separate statute. For example, in Pennsylvania, that is found in 18 PACS 302C, which states culpability required unless otherwise provided. When the culpability sufficient to establish a material element of an offense is not prescribed by law, such element is established if a person acts intentionally, knowingly, or recklessly with respect thereto. What does that mean? Well, it means that, say, if the theft statute doesn't state the necessary mens rea for somebody to be culpable for theft, then we know that, based on this catch-all provision, it is either intentional, knowing, or reckless, but not negligent. And really, it's sort of all subjective when you look at whether or not somebody has mens rea. Subjective mens rea means we actually look to the specific person to determine whether they had the requisite mens rea to make them criminally culpable in acting. That's based on someone's actual intent or their actual state of mind at that time. What someone should have known doesn't really matter. Only what they actually did know at the time of the alleged offense. And it applies for most forms of mens rea, the state of mind of that specific person, the person who is going to be put on trial and have to defend against the allegations of the state. For example, let's say Bob takes Cheryl's coat, and he honestly believes at the time that he took it that it was his coat, despite some indications that it may not be. Well, the requisite state of mind, let's say, for theft in that jurisdiction is purposeful or intentional. You meant to take it. You meant to cause the harm. Bob is not culpable in most jurisdictions because he subjectively would lack the requisite mens rea. And now's a good time for the disclaimer that I should have done earlier. Boozy's Legal Funhouse is an educational, informational, and hopefully entertaining discussion of general legal principles. While I am a licensed attorney, and as is Scuff, neither one of us are your attorney. Anything we say here is presumed to be general knowledge and is offered for informational purposes only. Please consult an attorney licensed in your jurisdiction prior to putting any of this into effect. Rather worrying that I have to say that, considering we're talking about criminal culpability tonight. Do not, under any set of circumstances, say a fat man on the internet who acts like a cartoon badger told me about this. So mens rea is subjective, except when mens rea isn't subjective. There are situations where we look objectively at the question of mens rea. First, we look at a hypothetical person, a hypothetical reasonable person, to determine whether the requisite level of mens rea is met. This is based on whether that hypothetical reasonable person, similarly situated and under the same circumstances, would have expected the criminal act to occur. What someone doesn't know or did know doesn't actually matter. The only question to be answered is, should they have known it, based on a reasonable person standard. And it applies only to crimes that can be committed negligently when you're talking about mens rea. Typically, those will be less serious crimes. It is the lowest form of mens rea that you have to have in order to commit an offense. Now, Scuff, I feel you chomping at the bit to mention negligent homicide. Would you like to explain that?
Well, interestingly, negligent homicide isn't really... it's almost not a thing anymore. Generally, it's only a misdemeanor offense, and it really only has to do with when you're in a car. what is often referred to by laymen as negligent homicide is actually reckless manslaughter.
Why don't you tell them the difference between the two real quick?
Oh, man.
I'm putting you on the spot, asshole.
Yeah.
You see, you warned me that you're going to nitpick something in this presentation, so I'm going to make you fucking suffer.
You're making me
that goddamn right I am.
There's actually, okay, there's 3 levels of what we would call negligence. There is the highest level of negligence, which is we call depraved indifference, which basically means I am acting in such a way that I literally don't care about the consequences of my actions, and my actions result in someone dying. A level down from that is I am behaving in a way that an objectively reasonable person would not behave. That's reckless. Negligence just means that I have some imposed duty of care in addition to just the way a reasonable person acts, and I act below that reasonable standard of care. That's why it typically applies to driving. You, as a person who's licensed to drive, is expected to follow traffic rules, which may or may not be the general reasonable person rules, but you're expected to follow them. If you don't follow them and you fall under a standard of care, you are negligent. It's slightly different than when we just say, like, me acting a fool outside gets someone killed.
Are you sure?
No.
I just had to. Are you certain you gave a correct statement? No, not fucking at all.
Nope.
Like I ripped that out of my ass. It was half.
I didn't rip it out of my ass. I was just trying to apply the general legal principles that I know about this. Very good point. I deal with a lot of crimes, but I almost never deal with negligent crimes because I haven't done traffic in over 10 years or over 9 years. So, like, traffic is generally where you find negligent issues, and negligent homicide is a misdemeanor. I don't deal with those crimes, so I don't deal with them very often. I deal with reckless, I deal with manslaughter, and I deal with depraved indifference murder. So those I do know.
So an example to kind of get this through is, let's take Bob and Cheryl's coat again. All right. So let's say that Bob takes Cheryl's coat and he honestly believes it's his coat, but there are many, many indicators that it's not. Maybe it's bright pink. Maybe it has a butterfly pin that Bob doesn't own on it. Maybe it says Cheryl's coat on the back very large. The requisite state of mind, let's say in this jurisdiction for that theft, is negligent by statute. Bob is still culpable. It doesn't matter whether he actually knew it was Cheryl's coat or whether he honestly believed it was his coat, because a reasonable person under the same set of circumstances would have known from those indicators that the coat was actually Cheryl's. Now, it's important to recognize ignorance is not a defense. When I say this, what do I mean? I mean, it is not a defense to say you didn't know something was illegal. Mens rea does not look at whether you intended to break the law. Instead, it looks at whether you intended to do an act, and that act results in breaking the law. And if you intend to do something and the result is a criminal harm, you have the requisite mens rea, regardless of whether or not you ever actually intended to break the law. The criminality is actually in the act, not in the intent to become a criminal in many cases. We say this.
Man,
pardon?
You need to teach that to more lawyers because I think you are now describing probably the number one thing that is taught in law school and immediately forgotten upon graduation. But yes, no, audience, this is one of the most important principles of criminal law that Boozy is talking about right now. Mens rea applies to acts that you commit.
And I will give the Latin real quick, which is ignorantia juris non excusat. Ignorance of the law does not excuse it. So you can't say I didn't know that was illegal and get away with it. Scuff, can you think of an example of an act that is criminal in itself where somebody may say, I did not know that was against the law?
I mean, any number of weird traffic offenses, like I turned right on red when I in a situation where I'm not allowed to, and there are tons of traffic offenses in states that you may not know are offenses, but you commit them because you just weren't aware that they were illegal.
Right.
Um,
And yeah,
importing alcohol from other states in certain circumstances is a crime, and you may not know it because not every state is it a crime to import alcohol from a different state.
and the general principle behind that is very clearly we expect the law expect. I don't expect it. I think all of you are lucky to if you have two brain cells that you can rub together and make a spark most of the time. But we as a society expect that people will apprise themselves of the law. They will be familiar with the law. They will be able to recognize when they are breaking it. And one of the harder things about that is, hey, Scuff, where's that big book of law that lists every law everywhere that's in an easily readable and condensed form?
Uh, I mean, most states can't even organize their laws so that the numbering system is the same. So nowhere.
So don't think I'm saying that if you're breaking the law, you're a bad person. There's a lot of laws out there that people just wouldn't think of. It brings us to a good difference here. Malum in se and malum prohibitum, which I didn't do a slide on. Malum in se is evil in and of itself. It is something that we have decided is bad because society deems it as bad. It is an evil act. Murder. Murder is a perfect example of a malum in se offense. You're not going to find very many people who are going to argue that there is no harm done by murdering another person. That's a common sense one, right? But then there's malum prohibitum. Malum prohibitum is something that is illegal or is evil because we say it's evil. It's not necessarily that it causes harm to other people. It's just something that we have decided as a society we will not tolerate. And I would argue that many malum prohibitum things that people are familiar with are traffic laws, are regulations, things that in and of themselves you would not think. You would not sit there and think, am I really doing bad by speeding? But for the necessity of a organized society, we treat them as violations of the law. That said, let's go back to virile. Yeah, I just said ignorance of the law is not a defense except when it is. While being ignorant of a law is not an excuse for criminal conduct, being mistaken about the facts that led you to take the act that was criminal may be. If a person is unaware of or mistaken about material facts that, if known, would have resulted in them acting differently, they may be held not to have the requisite mens rea for the offense. This is known as a mistake of fact versus a mistake of law. And essentially, it's I'm not a criminal, I'm just stupid. Examples of, say, mistake of law versus a mistake of fact. A mistake of law would be something like, I didn't know murder was illegal in your state. Or I didn't know the law said you had to have headlights on in the rain. Or I thought taking money from the register was legal. A mistake of fact is something like, I thought it was my coat. I genuinely believed I was breaking into my own house. Or I thought I had permission to drive their car to Mexico to buy a huge amount of cocaine. One of those three is a real defense that I'm sure Scuffs can tell us more about, because I'm certain Scuffs has actually at some point seen the prosecution of the drunk person coming home and they go to their old house. Have you've never seen that?
I don't personally think. I mean, I know it's happened, but I haven't personally had that happen.
Yeah, I've had that case. I've had the case
Oh, wow.
of the guy who got drunk and had moved recently, And the bar that he drank at was like 2 doors down from his old house. Well, he was so drunk he forgot he didn't live there anymore. And the entire argument was he wasn't,
Oh,
it wasn't felonious intent, Your Honor. He was just stupid. He was drunk and stupid.
For like trespassing.
Yeah.
For some reason I like got in my head you meant for a DUI. No, I have absolutely had.
No.
Okay, yeah, I have absolutely had trespassing cases where someone was super intoxicated and went to someone's house, and because it was their old house, and like they literally walk in the door and go up to the bedroom, and like someone starts screaming like, "Why are you in my house?" And they're like, "Why are you in my house?" Yeah.
How'd those tend to turn out? I mean, does everybody just crack a beer at the kitchen table and have a nice laugh over it?
Well, I mean, I just send them back to the municipal court and never hear about it again.
I never hear about it again. Yeah. Fuck it. Little Jimmy Drunkard's just got to break into that house every night for the rest of his life.
He gets a ticket from the city and he can be on his way, but it is not my problem. Because the reason I see them is that they're submitted as burglaries, but we'll get into that later. But I mean, actually, that's a perfect culpable mental. Burglary is the perfect culpable mental state case. But yeah, like they're submitted to me as burglaries, and it's like I can't prove that they had the intent to commit a crime.
Right, right. There you go. That's my thought too. Is what crime was committed there. Now, obviously, there are limits to the defense of a mistake of fact. First, it must be an honest mistake. You can't like sit there, see everything, and ignore it. And it must be reasonable. Under the circumstances, it must be a reasonable mistake of the facts. You can't sit there, come up with some bullshit, like I thought he was a space alien at the time, so I killed him so the Zarnonians wouldn't blow up the Earth. That's not honest or reasonable. No one's going to buy it. Further, you got to remember, it's the accused's burden to prove a defense at trial. Like generally in criminal matters, the accused has no burden whatsoever. They don't have to prove a single damn thing going in. The entire burden is on the state. All the defense has to do, in theory, is poke enough holes in the argument that the state cannot show beyond a reasonable doubt that criminal culpability should attach. But assuming that the state's going to be able to show this person should be criminally culpable, you have to raise a defense. And when you raise a defense, like mistake of fact to negate mens rea, you have to prove that to a judge or a jury, whoever the trier of fact is, that your belief was honest and reasonable to such an extent that you should not be held criminally liable for it. And every now and again, a mistake of law is a defense, because the law is made up. And it doesn't matter that I just said mistake of law will not excuse it. Every time we have a legal maxim, there's at least 2 or 3 exceptions to it. While the general rule of thumb is a mistake of law will not negate mens rea, there are limited exceptions, such as the law's never been published anywhere, so there's absolutely no way anyone could know it. The defendant relied on a law or a statute that was later overturned, so they thought it was still in effect. The defendant relied on a judicial opinion, maybe negating a law or a statute that was later overturned, or the defendant relied on an interpretation by some official who would presume to be an authority on the matter. Now, once again, the same restrictions apply as with the mistake of fact. Your belief when you're raising a mistake of law argument must be reasonable and honest under the circumstances, which means you can't rely on a 200-year-old ruling saying it's okay to murder somebody, or a law that was repealed in 1850, or things that would be within your common knowledge, something that is malum in se and that everybody knows is bad, or, importantly, a private attorney and asserting the defense of mistake of law. If I, as a lawyer, tell you it's okay to go rob a bank, you don't get to point back to me. Now, I've done a horrible job as a lawyer at that point, but you don't get to say, a lawyer told me I could do it, therefore I can do it. It has to be a public official, a mayor, a police officer maybe, a judge, somebody who you would think is a higher authority than Bob Esquire down the street. Now, let's ask a question about intentional cluelessness. I would like to introduce you all Close your eyes and come with me and imagine a magical unicorn, a beautiful unicorn, a rainbow horn, and we will call this unicorn Dipshit the Unicorn. Dipshit the Unicorn has traveled abroad, and while visiting a foreign country, was offered $100,000 to carry a suitcase back into the United States with them. That's all they needed to do. They were offered it in a dark alley by a man with a mysterious scar on his face. And Dipshit the Unicorn, who needs the money, decides they're going to do it. But they don't ask what was in the suitcase, and they don't open the suitcase, and they make the decision not to do either. So when customs inevitably finds the cocaine that is obviously in the suitcase, can Dipshit say they lacked the requisite knowledge to form mens rea because they had no idea what was in the suitcase? Assume, for the purposes of this discussion, that act, the smuggling act, requires someone to purposefully and intentionally act, so their actual knowledge of the criminal matter is needed. Scuff, what are your thoughts?
I mean, I'm cheating because I have your PowerPoint, so I went to the next page. So, but I was pretty sure the answer was no.
Yeah, you were pretty sure that Dipshit can't say they lack the requisite knowledge. That's right. That's 100% correct. The doctrine of willful blindness will impute, which is just a fancy fucking lawyer way to say assume that you had the requisite knowledge. From the case Global Tech Appliances Inc. v. SEBSA from the Supreme Court of the United States in 2011, and the doctrine's much, much older than 2011. This is just the pithiest way I found to say it. Defendants cannot escape the reach of these statutes by deliberately shielding themselves from clear evidence of critical facts that are strongly suggested by the circumstances. Which means when a situation suggests that something criminal is afoot, you can't escape your culpability for it simply because you choose to remain an intentional dipshit and not inquire reasonably to discover the things. If somebody walks up to you and says, hey, just walk this suitcase across the border and I'll give you $100,000, and you say, I'm not gonna look in the suitcase, well, doesn't matter whether you had actual knowledge or not. The law will assume that had you, like any reasonable person, asked the scarred man in the alleyway what was in the suitcase or opened it to see what you were agreeing to, you would have gained that knowledge, and that you intentionally decided not to gain that knowledge for the specific purpose of escaping criminal culpability. So, Dipshit the Unicorn, to Fairyland prison with you!
Fairyland prisons are very bad. I heard they privatized a couple years ago, and it's just nasty.
Just the fucking goblins there feeding out meals that they bought for 50 cents on the dollar. Like, has grade F bologna stamped on the bottom of every sandwich. Oh, so a summary to this point. Criminal culpability will require both the requisite intent to engage in an act and the act itself. Mens rea, the state of mind, is generally a subjective question specific to the alleged perpetrator and not an objective one, except in very limited circumstances. The requisite state of mind for an offense is determined generally by the statute for that offense, and if it's not defined there, more than likely it's going to be codified somewhere in a catch-all provision in the state statutes. And while being mistaken as to the law is not a defense, being mistaken as to the facts may serve to negate the mens rea requirement. Finally, much like Dipshit the Unicorn, you cannot willfully make yourself ignorant of the facts solely in order to escape the mens rea requirements when the circumstances make it clear you should have inquired further. And then we have the purpose for tonight's discussion. Strict liability. Strict liability on the criminal matter is an exception to the mens rea requirement. It basically is saying that you don't have to have a guilty mind when acting to be held criminally culpable. A strict liability offense is one where it does not matter if a person intended to break the law or take an act that resulted in the breaking of a law or not, because the mere fact that a criminal act occurred is enough to convict. Examples of such common strict liability offenses are, well, speeding, property ordinances, parking violations, Simple things, small things most of the time. It doesn't matter whether you intended to speed or park in the wrong place. The fact you did it is enough. Why is strict liability even a thing, though? The law jealously protects people from being held criminally culpable to the point of Blackstone's ratio, where it is better that 10 guilty men go free than one innocent man go to jail. Well, it's actually an outgrowth of the Industrial Revolution. In the 19th century, as industry geared up and factories became more common, they figured out that factory owners may not be the most ethical people out there and may actually break laws in order to increase their profits. However, at the same time, they understood that it would be very hard to show that these factory owners had a culpable state of mind in doing so. Their intent was not to break the law in many cases. And generally, how do you prove that? So they made a public policy decision. The decision being that in order to promote public welfare and hold people to these regulatory standards, they would make it enough to say the fact the crime was committed can lead to culpability. Strict liability, though, was never really intended for serious crimes. Generally, it was a concept that was to apply to crimes where the punishment was less than imprisonment. Think about it. If a factory owner breaks a law, you don't tend to put them in jail. The punishment tends to be a fine. It tends to be something along those lines. The idea generally at that point was that in situations where the punishment was not severe enough to result in a significant deprivation of liberty, the application of strict liability would be permissible. And in all other cases where a person would be significantly deprived of liberty, thrown in jail, due process in theory required there be proof of a guilty mind, the mens rea requirement. However, strict liability became a bit of a slippery slope. Public welfare sort of got broadly defined. In the interests of public welfare, which was an exercise of the state's police power to protect the morals and safety of the public, strict liability in many jurisdictions has been expanded to include such things as possession of drugs, drunk driving, and statutory rape, regardless of knowledge of age or even deception about age. The justification is that those offenses are so against the public welfare that the mere fact they are committed means no mens rea should be required to be proven in order to hold somebody culpable. And why is this an issue? Well, strict liability significantly limits a person's ability to defend and forecloses evidence of intent from being considered. For example, a person who unwittingly is in possession of drugs can be held liable for such possession, regardless of whether they even knew they had them on them. And a person who honestly and in good faith believed a partner was of age and may even have been presented with evidence indicating they were of age can be barred from presenting evidence of that effect to a court. The mere fact in a strict liability offense that a crime was committed is enough and generally cannot be overcome unless a mistake of law can be argued or you can actually show the accused did not commit the alleged crime. Penalties can actually be severe, including significant prison time, in some cases up to 5 years in prison. Let's give us an example of the issue. Say Tom boards an airplane and he places a gray case on a conveyor belt for inspection along with his luggage. The security officer opens the gray case and finds a pocket knife. He opens the luggage and finds a butcher knife wrapped in some clothing. Tom is then swiftly arrested for violation of 49 U.S.C. 1472L, which makes it a federal offense to attempt to board an airplane with a concealed weapon. Tom is a chef. The butcher knife was put in his luggage at the last minute with the intent to take it to a friend's house. The pocket knife is something he carries all the time, and he does not believe it to be large enough to be considered a weapon. Should Tom be convicted of this offense and spend a year in prison? Well, The answer is Tom's going to jail. 49 USC 1472L is a strict liability offense. It doesn't matter whether Tom believed the butcher knife wrapped in clothing and his pocket knife matched the definitions of concealed weapons. It doesn't matter that Tom knew or believed these items would be readily discovered in an inspection and he was not trying to conceal them. It doesn't matter that Tom has an explanation, an innocent explanation for a butcher knife in his luggage, and Tom cannot present any of these justifications to a jury. The mere fact that the weapons were concealed and that he was ostensibly concealed, I should say, and that he was attempting to board an airplane with them is enough for the conviction. And the penalty for this is up to a year in prison. And in case you think that that was a hypothetical, it's not. That's an actual case out of the 8th Circuit Court of Appeals, United States of America v. Thomas Lawrence Flom, 8th Circuit, 1975, where the court decided that it was not for them to allow the introduction of that to overcome strict liability and force the suggestion or contemplation of the mens rea. There are limits to strict liability, though. The court can't just criminalize anything. Your legislature doesn't have that power. Wholly innocent conduct unrelated to public welfare generally cannot be criminalized via strict liability. Conduct that by nature is essentially innocent, such that nobody would expect it to be criminal conduct, cannot be subject to strict liability. That actually comes from Lambert v. California, a 1957 case regarding a Los Angeles ordinance that required everybody who came into Los Angeles to stay to register with Los Angeles within 5 days. Likewise, passive non-conduct cannot render somebody strictly liable without violating due process concerns without something more. That comes from Papa Cristo v. City of Jacksonville, a 1972 case. All of these Supreme Court cases, by the way, where a lady had been arrested for, believe it or not, violating an ordinance that barred walking at night. Generally, this is not to say that that can't be criminalized at all. Only that due process demands the mens rea element be presented, because the conduct that is criminalized is otherwise innocent in nature and does not indicate criminal liability. So the final takeaways. Criminal culpability requires requisite intent to engage in an act and the act. Mens rea is generally a subjective question, not an objective one. Requisite state of mind for an offense is determined by statute. Generally, a mistake of law is not an offense, but a mistake of fact may be. You can't willfully make yourself ignorant to escape liability. And strict liability means it doesn't matter if you intended to break the law or not, because it makes the act itself enough for conviction, unless the conduct criminalized is obviously criminal in nature. And that leads in to our discussion point for the next 30 minutes. Washington's possession statute. The Washington Supreme Court had previously stated possession, specifically RCW 69.50.4013.1, was a strict liability offense with no mens rea requirement. Given what we know, is this correct? That statute states it is unlawful for any person to possess a controlled substance unless the substance was obtained directly from or pursuant to a valid prescription or order of a practitioner while acting in the course of his or her professional practice, except as otherwise authorized by this chapter. Scuff, what are your thoughts? Not getting into the case we're going to be talking about tonight.
So, my thoughts generally on strict liability, or my thoughts on the Washington statute?
Let's go with strict liability first.
I think there are public policy concerns that legitimize using it in serious cases. And I think one of the places you can look to really talk about where the big battle on strict liability is coming is on insider trading and a lot of people don't know this. So a lot of people, when they talk about strict liability, come from a criminal justice reform that kind of tracks what we consider liberal or libertarian grounds, but there's actually a huge conservative movement against strict liability, specifically because financial crimes are mostly strict liability offenses. The act of trading is what gets you in trouble. The conditions under which the trading happen are strict liability. It doesn't matter if you intended to use those conditions for criminal activity. The mere fact of trading with those conditions attached gets you in the legal trouble. And I think that's a legitimate reason to have it. And many of those crimes carry significant prison time if you engage in them.
All right,
So
but to
I
contrast
think,
that, how's that different from, say, somebody's walking up the sidewalk, I'm scared, so I shoot them?
well, I
Hey,
mean,
the act of shooting them is what got me in trouble.
right?
The
But
circumstances are what leads up to me acting to shoot them. And under those
sure,
circumstances, I
and
wouldn't be justified either way.
yeah, but again, but that affects the level of offense, right? I mean, if those circumstances are true, you are not guilty of murder. You are guilty of manslaughter. You're guilty of what we call in the business imperfect self-defense manslaughter.
But was it
And
true? I mean, they're just walking up the sidewalk. Without something more, I don't even think it meets self-defense
well,
standards.
right. I mean, like, but it's it if I were a prosecutor, not saying I am, but if I were,
You are.
I am, I would charge that as second degree intentional murder. You intended to shoot the person because you were coming up behind them. But at trial, I'm going to have to instruct a jury on second degree intentional murder. I'm going to have to instruct the jury on imperfect self defense manslaughter. And the argument they're going for is imperfect self defense manslaughter. I was scared. Well, they're going to go for self defense, but the defense attorney is going to hedge towards they were scared. And the real question is, was their individual subjective belief true? Did they truly believe they were scared? If so, it may not have been a reasonable belief. In that case, it's manslaughter, but it was a true subjective belief.
So, I mean, but we've already covered that the intent is in the act, right?
Right.
Okay. So let's say for the insider trading example, right? I have all this knowledge that puts me in that insider trading class. The act itself is just adding on. I intentionally did the act that violated the law. I didn't accidentally hit sell on my stocks. I intentionally did it with that knowledge, with the knowledge beforehand.
But
It doesn't matter whether I intended to violate the law or not. I intentionally undertook the act.
But strict liability offenses often have this dualistic mens rea requirement, right? Like a statutory rape is the perfect example. You have to knowingly have sex. The condition that you are knowingly having sex with someone below the age of maturity is the strict liability. It doesn't matter whether you knew that they were under the age of maturity, but you have to have knowledge as to whether or not you're having sex. If I'm unconscious, I'm not guilty. Period. I mean, but like that's. I mean, but so the
I would
reason
argue. I would argue if you're unconscious, there's more than one crime being committed.
right, exactly. But I mean, my point is, often with strict liability offenses, there still must be an accompanying act, but the result, you don't have to have any sort of requisite mental state for the remaining things after the act. You just have to act.
Well, what would you say to the thought, though, that perhaps in certain situations, rather than strict liability, we should just lower the level of mens rea necessary to meet it? A reckless instead of intentional liability level mens rea requirement for, say, statutory rape.
I think that's something that is. I think that's certainly something that's possible. I think one of the big misconceptions from people who there's always going to be outliers, right? There's always going to be cases that are decided that seem like really outside the bounds of what you would expect. For instance, Tom's case on the airline. But in general, with statutory rape cases that I've seen, even though they're not allowed to consider it, juries often nullify based on how old the victim looked, whether or not she consented, who came on to who, even though legally they're not allowed to consider any of that. The reality is people do. I don't know that it changes much, because I think that's, even then, if I'm a prosecutor and I'm prosecuting a statutory rape case, I'm knowing that a jury may nullify, I'm already going to go through stuff like, did you ask how old she is? Did you like this and this and this? Like, did you have a conversation with this person before it happened? I'm going to try to pin down those defenses anyways. So at the end of the day, I think it's one of those issues where it might help. I think it's also kind of one of those areas where juries aren't mechanical. They're not computers. They don't process information the way we want to, or the way we would expect them to. And so sometimes it doesn't actually matter that much.
Well, whether it matters or not, though, should we be foreclosing the defendant's avenue to say this wasn't, I never would have undertaken that act had I known these circumstances existed?
I generally oppose, I mean, like, I'm a prosecutor, but you know me, I'm like a super progressive liberal. So I generally oppose any sort of laws that foreclose defenses, unless the defense is completely, like, unless it's been perfectly scientifically shown that that is not a defense and it's complete bullshit. And that's very rare. I'm not the kind of person who generally supports foreclosing defenses. It's, I don't know, like, it's weird to me because I've never worked in a jurisdiction with a strict liability drug possession laws.
And that's
Um,
a good lead in, because what the case that I wanted to discuss in the last 30 minutes is actually a recent case. It's out of Washington State, where we telegraphed it a bit there at the end, where the Washington Supreme Court had previously held that drug possession was a strict liability offense. It did not have any mens rea requirement. The mere fact that you had the drugs on you and they were not prescribed was enough to lead to liability. And in some cases, 5 years of imprisonment as a result thereof. They had previously tried to carve out an exception called the unwitting possession defense, which was basically showing you didn't know you had it. But very recently, and I'm going to switch over to it, the Supreme Court of Washington, in the case Washington v. Blake, came back in an en banc panel, which en banc is just a fancy way of saying the entire panel set on this, decided that drug possession should not be a strict liability offense. The reasoning given for this is that, and it's probably to some extent the holdings in Washington regarding decriminalization, but the reasoning on this was that it would criminalize otherwise innocent behavior. Now, what's the innocent behavior? Because in this situation, in this specific case, it was not a question of they could legally have the drugs or thought they were allowed to legally have the drugs. The fact pattern here is Miss Blake's friend bought a pair of secondhand jeans and loaned them to her. And Miss Blake put them on and was arrested later with them. And there was apparently a small bag of methamphetamine in the pocket of the jeans. At trial, Miss Blake brought up and said that she did not know there were drugs in there. She had never used methamphetamine. She did not know the jeans had drugs in the pocket. She did admit that the drugs were on her, and she had testimony that she did not use drugs and that the jeans had been a gift from a friend 2 days prior. The court, hearing all of that, stated that it did not matter, that she had failed to meet her burden for unwitting possession, and accordingly was found guilty. And the question at issue in Blake was really, should she have ever had to prove unwitting possession? Should she have had to prove that she was not aware of the drugs in there? Or should the prosecution needed to prove she was aware and that there was mens rea applicable here.
So, and again, this is one of the reasons that Boozy gives a big disclaimer at the front about the fact that we're not your lawyer, is that laws are different in every state. In the 2 states I have practiced in, Illinois and Kansas, possession requires 2 elements that you have to prove. It's not, possession doesn't mean I had something on me. In Illinois and Kansas, possession has 2 elements, and those are knowledge and control. So the state bears the initial burden of proving that you knew the drugs were there and that you had control of the drugs. So in a case where drugs are in your pants, I can prove control, right? They're in your immediate reach. They're under your auspices. You have control over them. What I have to also prove is knowledge. What is interesting about the Washington case is that they said because Washington has a specific separate defense that isn't triggered by the state's burden of proof, it violates due process. Meaning that before I ever have to prove knowledge, you're required to prove ignorance. And what the Washington court said is that that is a violation of due process. That I don't think is wrong, like legally or morally. I think possession should require both knowledge and control. I think that's a moral understanding of what possession is. Whether it would change much in terms of like how you charged it or where the case comes down is a totally separate issue. But I think the Washington court made the right call. That's not how I think possession statutes should be written.
You are rewriting my perception of prosecutors in general right now. I have to say, because my immediate thought was when you came on, when you said, hey, I want to be on tonight to talk about this, that me and you were going to go like bare knuckle boxers on this because I 100% agree with you. You can't prove a negative. How are you ever going to prove that you did not intend to possess drugs? And that's it. They're found on you in pants you're wearing. How are you ever going to prove that you didn't intend to possess them? And yeah, you can have as many people as you want come in and testify you're not a known drug user and all the facts about it, but is that going to get it past it? I'll tell you a story. My mother-in-law served on a jury where the case was the same. It was possession. It was possession of a drug. And the defense that was being raised, and Pennsylvania doesn't have the strict liability, but the defense that was being raised was, I didn't know it was there. And you know where they found it? They found it in a backpack in the attic of the house. A backpack in the attic of the house that the person had just bought. Their defense was, I didn't even know there was marijuana in that backpack. That backpack was here when I bought the house. I just bought it a few days ago. I haven't gone through everything in the house. I had no clue. You know what the result was? They were convicted. They were convicted of having that marijuana. You look at me as a defense attorney, and I'm going to say, that sounds amazingly reasonable as a defense to me. I just bought a house in an economically depressed area. Somebody left their fucking backpack in the house. The backpack had pot in it. That sounds reasonable to me. They were convicted. A jury looked at it and said, nope, I don't believe this motherfucker. And there's many reasons a jury may not believe that motherfucker. I feel very strongly in that case that the reason the jury didn't believe that motherfucker is it was a relatively young person in that area who had just purchased a house. Now, I was very happy to hear that my mother-in-law did believe that motherfucker. So how were they convicted? Because the rest of the jurors overcame my mother-in-law's objection. And when she asked me, what should I have done? My response was, you should have stood firm. If you didn't think that they were guilty, you should have stood firm. Because now this poor motherfucker has been convicted. And that's your duty. But
I wonder if they pulled the jury.
they did not. They did
Oh
not.
well, that's always a mistake.
I asked
Always a
this.
mistake.
I asked the same
Always a
question.
mistake.
I asked the exact same question.
I don't know how many lawyers listen to your chat, but if you are a lawyer and if you are a criminal defense lawyer and if you have ever gotten a guilty verdict and you do not pull the jury, you have committed malpractice.
Oh yeah, you always need to know.
I am, and I have only ever worked as a prosecutor, but I have gotten a mistrial. I have gotten a mistrial because a defense attorney pulled the jury.
Yeah,
I got a mistrial. Other way around. Because I pulled the jury.
And it really is, it's the truth. It's the truth. What polling the jury is, by the way, just to explain for the non-legal listeners, after a verdict is returned, you can request to poll the jury. And polling the jury is actually going to each juror and asking what their verdict is. It's open court, and juror number 1, how do you find? Juror number 2, how do you find? Juror number 3, how do you find? And they have a chance to repeat their verdict in open court away from the pressures of the jury room. And sometimes, especially with mistrials or hung juries, which are technically mistrials, but hung juries, it's very useful for the defense and the prosecution to poll the jury because how many votes did I get my way? In that.
Oh, see, we can't pull in a
we
hung
can.
jury.
We can.
Oh, yeah, in Kansas we cannot pull in a hung jury.
No,
we can only pull in a guilty or not guilty jury.
We can pull in a hung jury. But the other end of that is what Scuff is alluding to, which if you have a juror who is under pressure in the jury room and is agreeing because there's 13 other, how many alternates do you all have up there?
It depends on the level of the case, but one or two.
There's other people in the jury room who, maybe it's 11 against 1. And that one person is being pressured and pressured and pressured to just throw in with the other 11. And finally they give in. They now have another chance on that polling to stand up and say, not guilty or guilty. They have that chance to change their mind. And it's not even changing their mind as much as removing them from the pressure at that point. Now, Scuff, what is the result of polling the jury?
If a juror changes their verdict in a poll, it's just a mistrial. Like, they don't send them back to deliberate. And in a mistrial, basically is legal speak for the trial was so erred by something that we have to start over at the beginning. We get rid of that jury and we have to try the case again. So if a juror changes their verdict during polling, it is a mistrial immediately. They don't go back and deliberate, and we have to start over.
Now,
if you're a defense attorney, good, you like that. Because I'm going to tell you, in 11 years of prosecutorial practice, a case has never gotten better the second time I've tried it.
Well, and a lot of times I've said it before, which is I've hung them once, I'll hang them again. I can hang them till the end of time because you need 12 and I need 1. So how about we make a deal?
That typically happens. So the strict liability on drugs is something that's coming up in a lot of jurisdictions. Kansas actually had a case on this that was similar but different. Most of the law is similar but different. So in Kansas, like in Illinois, as the prosecutor, I have to prove possession, which means I have to prove knowledge of the thing you are possessing, and then control over it. And I have to prove both of those things. So the secondary element there was strict liability to. So if you have a bag in your pocket and it contained a white powdery substance, and I could prove that you knew you had a bag with white powdery substance, and I can prove you can control it because it's in your pocket, but you're like, well, I thought it was, laundry detergent. I was, my friend Jeff gave it to me. I was on my way to wash my clothes. In Kansas and in Illinois, it did not matter that you thought you had laundry detergent. It was strict liability as to the substance. So if that substance tests positive for methamphetamine, it doesn't matter that you didn't know it was methamphetamine. All that mattered is that you knew you had the bag. In Kansas, that is just now changed. But what's different than Washington is Washington just struck down their drug law, which means that the legislature has to go back to the drawing board and write it back up with the right mens rea in it. Like, no one can be convicted under an unconstitutional law. So if people want to convict you, or if they want a drug law, they're going to have to go back and make it constitutional.
And
In
that
can
that actually brings up a good point right there, because it's one thing we did not cover right at the beginning of it, but we should, and I'll go to that part of the opinion, which is this phrase right here: as we have held for nearly 40 years, if the legislature had intended guilty knowledge or intent to be an element of the crime, it would have put that requirement in the act. Now, I'm not a Washington attorney. I could be reading that incorrectly. But the implication of that to me is that any crime that does not specifically state the mens rea element is technically strict liability in Washington.
Yeah, that's really odd to me, because you were talking about the Kentucky culpable mental. I call it culpable mental state because a lot of states have moved away from using mens rea and they call it that. But basically, the mens rea statute that you were quoting, literally word for word, that is the exact Kansas one.
Yeah.
So if it's not in this, and that's same for Illinois, same for a lot of places.
Yeah, I mean,
if it's
most
not
jurisdictions.
In the statute, yeah, if it's not in the statute, the court typically reads in what they think is required. So what happened in Kansas is real different than what happened in Washington. What happened in Kansas is they ruled that without a specified mens rea requirement as to knowledge about what the substance was, we read in intentional as to the substance. That did not strike down the law as unconstitutional. What that did is said that there is an additional thing that the state has to prove, and then the court in that case, interestingly, the court in that case did not reverse the conviction. What the court did is they treated it as what we call in the business a sufficiency of the evidence. So generally speaking, the jury is the one who decides if you're guilty or you're innocent. But courts on occasion can be asked to look at the evidence and basically decide, was there enough evidence to find you guilty, regardless of what the jury said. And it's a really high burden. Courts generally will find sufficient evidence. It's almost never the case that they don't. So what the court did is they essentially said, okay, well, we're going to look at this as if the jury had been considering their intent to have the substance, and then they found that there was sufficient evidence because there was a lot of evidence that they had intended to possess a substance. Here's the weird hiccup with the Kansas decision, and this is actually something that I'm curious about your opinion, Boozy. The court said it doesn't matter what illicit substance that the person intended to possess. It only matters that they intended to possess an illicit substance.
Well, fuck that.
Yeah.
Like the levels, the sentencing guidelines, all that's dependent in many places on what substance we're talking about.
Right. So, like, it wouldn't matter that the person said, well, I thought it was cocaine, but it's actually methamphetamine. And in Kansas, those are the same level of offense, but they're two different statutes. It's two different statutes, two different crimes. The court said all that matters is your intent to be committing an illegal act. It doesn't matter what the substance ends up being. So it's a very weird compromise. It's not quite what Washington came up with, but it's different.
I mean, like, I guess I can see it to some extent if you knew you were possessing an illegal substance, a substance that you cannot argue was legal in any way. Then I could see the transferred intent on that. I could see that. I could see almost like I meant to shoot Bob, but I ended up killing Mary. You know, I could see the transfer of intent in that, which is a whole thing we're not getting into, is transferred intent. But I could see that. I could see the transference of intent if the offenses were significant, like if the sentencing guideline for one was significantly different than the other. I would argue that you have a significant issue there, though, on it. to some extent. And why is this so important? The strict liability. Well, I just wanted, before we go to questions, pop back over to the Washington Memorandum, which has a very good, it's at page 16, has a very good discussion of felony convictions and drug offenses and their effect. As they point out, felony convictions will strip many defendants of fundamental rights during incarceration and afterwards. Drug offenders are subject to countless harsh collateral consequences affecting all aspects of their lives, including the denial of more than 750 federal benefits and consequences related to healthcare, education, employment, housing, parenting, professional licensing, and others. Imposing such harsh penalties for innocent passivity violates the federal and state rule that passive and wholly innocent non-conduct falls outside of the state's police power to criminalize. And with that, let's turn to our questions from our Patreon supporters over at lawyersandliquor.com/Patreon, as well as the subscribers of the Twitch channel that we broadcast our live recordings on. We have one here from Slippery Stallion. We're holding a certain amount of drugs with no excuses earns the death penalty, such as in Singapore, and that would be, I mean, in my opinion, that's a pretty goddamn serious strict liability offense. I do not believe that would ever, for the same reason that the punishment of a couple years in jail may be too harsh for strict liability and should require mens rea, I would argue that any offense carrying the death penalty cannot be strict liability constitutionally in the United States. Your thoughts, Scuff?
I mean, yeah. I mean, I think the only crimes in the United States that can carry the death penalty in any state, maybe not Texas, but have to be premeditated. I think every capital murder offense requires premeditation.
I think some felonies actually can fall under it. I think. Well, I'm not certain.
Under the U.S. Supreme Court, the only cases that can result in the death penalty anymore have to be homicide.
Yeah. Well, yeah. Yeah. No, but like everything's homicide. Any killing's technically a homicide. It's murder.
Because I don't, and again, like Texas and Louisiana fuck everything, and so like you can say generally like the rule, or you can expect this, and then Texas and Louisiana come along and like, haha, motherfuckers, you forgot about us.
we don't count Louisiana anymore. Louisiana is, we've kind of cordoned off Louisiana to their own little legal system and left them alone.
In most states that I know of, the death penalty is reserved for a premeditated killing. Now, in certain states, the additional requirements for the death penalty to be imposed are much higher than others. In certain cases, like premeditated murder in and of itself could be capital. But in like Kansas, capital has to be premeditated murder of a police officer, premeditated murder of someone in order to cover up another felony, premeditated murder involved in a rape or other sexual crime, premeditated murder of a child under a certain age, or premeditated murder of 3 or more people.
Well, what we would generally call depraved heart murders. Generally,
that's not capital. I mean,
we actually, because I don't know, I've heard depraved heart is essentially you didn't just kill him. And you didn't just mean to kill them. The circumstances under which you killed them are pretty fucking bad, man. It's more than just, I want to kill somebody, so I'm going to kill somebody.
Well, it's interesting because, like, when I hear depraved heart murder, typically when I hear that phrase, it's used as depraved indifference or
no.
Okay,
two different things.
Things. Okay. That's why I was confused for a second, because like when we would, like in Kansas, we call depraved heart or depraved indifference murder, which is second-degree murder. It's a lower level of offense than
I'm actually while we're here, I'm going to look it up and make sure that I'm not correcting you incorrectly. This is the wonderful thing.
It's one of those weird things, like you learn all this shit in law school, and then you get out of law school, and then every state uses it wrong, like assault and battery. Like some states
you're right. Depraved indifference. You're right. You're right. I don't know what I'm thinking of, but there is something with the word depraved in it that is a level level of murder where it's not just, you didn't just kill them, you tortured them before you killed them.
Yeah, I'm sure there is.
It uses the word depraved, and that's probably where I'm getting depraved heart for. from. Dave Lister has brought up in the chat that treason qualifies for the death penalty. Yeah, but how often is it actually carried out?
I think even then, though, the treason would have to result in like the loss of a life. I don't know that all levels of
No,
treason.
no, I think federally it doesn't have to.
Oh,
Federally,
really?
I believe treason and espionage, I believe, are.
I wonder if that's ever been. Well, here's the thing, though. So there was a Supreme Court case that came out about 9 or 10 years ago on Louisiana sex cases, because Louisiana was one of the only two states left in the United States that allowed the execution for sex offenses
Yep,
against a child.
yep, yep.
And the Supreme Court found that no, you cannot execute someone for that. It is only murder. So it's entirely possible that treason may not carry the death penalty anymore. It may be on the books, but if challenged in front of the Supreme Court,
I don't
they
think
may
we.
find that it
Yeah,
can.
I don't think we've ever actually sentenced someone to death for treason
Yeah.
outside the Uniform Code of Military Justice.
Well, and also not for like 70 years, 80 years. I mean, like, when was the last time someone was executed for treason?
Yeah.
So, I mean, like, this is the weird part about the law is sometimes you have an on-point case that absolutely tells you what the law is, but it has other cases that would theoretically violate it haven't been challenged to the point that you can say for certain that it isn't. But I actually wouldn't be surprised. Oh, the only person who has ever been executed for it was in 1862. Okay, well, Dave Lister, in the 1800s, you could execute people for a lot more things than you can now. So,
well, rape used to be a death penalty offense.
yeah,
Rape used to be a death, in almost every jurisdiction. Rape used to be a death penalty offense. Horse thieving, you could hang someone for horse thieving and cattle rustling.
Can I tell you something that is tangentially related to this conversation?
Only if I can afterwards.
In my old job, we ate lunch in a law library, and there were these old law books, like going back to the 1800s. And in one of them, we were just kind of curious, looking up some things, and for some reason, someone turned to the affirmative defenses for murder, and it used to be an affirmative defense to murder that you were engaging in discipline of a child or your spouse.
Oh my God! That's whoa!
Oh, or a servant. No, or a servant. I forgot about that one.
Uh-huh.
Or a domestic servant. It used to be a defense to murder that you were disciplining your wife, your child, or your servant. I am not joking.
You ever heard the defense to murder of he needed killing? I feel that people that asserted that affirmative defense needed killing. Jesus Christ. Which just goes to show the law is a constantly evolving creature. You definitely cannot beat your spouse or child to death today as a form of allowable discipline. From Quaxum Effetida, we have strict liability presumes the defendant still performed an action regardless of whether they were aware of its illegality. Is an action performed under duress a defense against a strict liability offense?
Yes, duress is always an affirmative defense.
Right. Well, it is and it isn't. It's always an affirmative defense. An affirmative defense being one that you prove the circuit. Basically, even if everything they said was true, I still win because X. And X is your affirmative defense. And duress, which means doing something under pressure, which isn't just like somebody's ting-tonging you to do it. Somebody's telling you got to do it. But we are talking extreme pressure, normally threat to safety, life, limb welfare, or one that would be reasonably expected to cause you significant duress, such as threatening your child. The only time I can think of that duress is not a defense to a crime is murder. And the reason I say that is it is and this is going to differ via jurisdictions, but the general rule used to be, it may still be, that duress is not an affirmative defense to murder, because who are we to say one person's life is worth more than another's? You can't murder somebody and say that you had to do it to preserve your own life. I don't know if Scuff is in shock or frozen.
No, I'm actually I'm reading Kansas's statute on compulsion right now because I wanted to see if it was
compulsion. By the way, is just another word for duress.
Yeah, and it does KSA 215206. A person is not guilty of a crime other than murder or voluntary manslaughter by reason of conduct which such person performs under the compulsion or threat of
Imminent.
imminent infliction of death or great bodily harm. If someone reasonably believes that death or great bodily harm will be inflicted upon them if their spouse, parent, child, brother, or sister, if they do not perform the conduct.
Right.
Interesting that it's got a specific list of which family members you can be.
Right. Which ones will allow you to commit a crime if you're being compelled, and which ones will,
Yeah.
if it's a guy down the street and they put him in front of you and they'll like rob the banker, will kill him. You're supposed to say "fuck you," kill him. I don't care. I don't care.
Yeah, exactly.
I don't know that motherfucker. He can die.
Your roommate, like, I'm holding your roommate hostage, but yeah, no.
Oh, and finally, we have a question from Dave Lister, who has asked, "How does diminished mental capacity affect mens rea?" We could do an entire stream just
We
on
should.
that question. Yeah, we
should.
should. We definitely
Because
should.
that's the Supreme Court case on the insanity defense is actually a Kansas case, and I know it very well. In fact, I'm very good friends with the person who wrote the state's brief on it, and I followed it, and it's a that's way too long. I mean, like, that's an hour and a half discussion on its own.
In general, yes, diminished mental capacity can affect a determination of mens rea, but going into an analysis of when and how is more time than the 2 minutes we have left. So that will do it for episode 7 of Boozy's Legal Funhouse. Men's Room Rea and Strict Liability. I want to give a special thank you to Scuff and Dings for coming back on. Scuff, you're open for that. We'll have to get together and decide when we're going to do that diminished capacity one, because I'm down for that discussion.
Absolutely.
I'm down for it. That's maybe we should find somebody from Texas and ask they does diminished capacity negate men's right? No, light them up. Yeah. Which is like that sounds blunt and very off color, but seriously, no, that's how Texas looks at it for a lot of diminished capacity. Nope, light them up. That said, you can catch us every Monday at 7 p.m. Eastern on the Twitch channel for the live recording. If you're listening to this on the podcast service, thank you very much for doing so. Please, I'm going to ask of you to rate it 5 stars. I don't give a shit whether you like it or not. I just want to get it out there. If you want to support us, you can do so over at patreon.com/lawyersandliquor. That'll get you access to the Discord channel where we talk about these things, solicit questions for the streams, play games together, and generally chat during the day. All of that said and done, my guest tonight has been Scuff and Dings, a prosecutor from Kansas.
It's been a lot of fun. I'm really glad you had me on.
As always, it's been a pleasure. I am the Boozy Barrister, Boozy Badger, and that will do it for episode 7 of Boozy's Legal Funhouse. We're going to talk as the credits roll. Thank you, everyone, for tuning in, and have a wonderful evening. Good night. That went well.
Yeah, it was a lot of fun.
I always enjoy having you on.
Oh, thank you.
You're a good guy.
I'm surprised you were expecting me to defend the Washington strict liability statute.
Well, you're a prosecutor.
I know, always, but you know me.
I always assume that prosecutors are going to take the worst stance humanly possible, whether I know them or not.
But the interesting thing, and this is what I was expecting you to ask, is like, would that have changed my charging decision? Because I have it was someone else's pants cases all the time. I mean, that's literally the most common defense to possession.
Can I ask who's doing that? It wasn't
my pants.
Like who's going to the Goodwill and not checking the pockets of their pants before they put them on for methamphetamine? You'd think of most people, that's the first thing they do, even if they were just looking for a little present in their pants pockets. Just a little meth. Yeah, I only paid $3 for these jeans, and I got a shit ton of meth.
Yeah, I got $100 meth in these jeans. The interesting thing to me is the reason that case in Washington is so crazy is because they struck down the law. I would have, in when I was reading it, I just expected that they sent it back and that they were going to have to like retry it with a different standard of proof. When I saw that they struck it down, I'm like, oh my God, holy shit.